In today's workplace, things are evolving quickly and complexity is the norm, but clarity is a choice. This Week at Work is where leaders get practical solutions and timely insights for today's toughest workplace challenges.
Hello, everybody. I'm Phil Brandt, President and CEO of AIM Employers Association. Welcome back to another episode of This Week at Work. Can smart glasses transform productivity and safety at work, or create new risk for privacy, compliance, and employee trust? In this episode, we will explore wearable technology, reshaping the workforce, and what business leaders need to understand before adoption. Joining me, as always, is Bert Garland, shareholder and friend of mine, co-host from Ogletree Deacons. Bert, good day. How are you doing?
Phil, I'm doing great. I'm just coming off graduations for my two middle kids, one from law school, one from getting his master's in mechanical engineering. And you know, it just kind of made me think, Phil, sometimes you just got to
Whoa,
say
whoa, whoa,
what
whoa.
the
Don't say it. Don't say it. Don't say it. Don't say it. Don't just stop there. This
what,
is a
Phil?
PG program.
All
PG
right.
program. But I will ask, Bert, I mean, you do have that risky business look about yourself, and I know you're feeling quite, quite squirrely a little bit coming off both your kids graduating and moving forward in life. And I know you and Amy are really proud and you've done a great job with your kids. But as you have the risky business look, and this is a PG program, this is for our business friends, you are wearing not just boxer shorts, right?
Phil, I think you're getting a little too personal there.
This work from home thing. Okay, I get it. All right, we're going to keep it right there.
All
All
right.
right, Bert, this is good program. We're going to talk about wearing recording devices such as smart glasses in and around the office. It's a hot topic. It happens, and sometimes we don't even know it's happened because of the advancement in technologies and styles, and
Mhm.
there's so many things for us to talk about in this episode. But before we do that, I know our listeners love the Lawyer on the Clock segment, and I don't want to miss that. Are you open to Lawyer on the Clock?
I am, and I'll make it really quick, Phil. The
All right.
first one I'm going to chat about, this came out literally after we did our last program 2 weeks ago. I think it was the same day or the day after, and the Department of Labor, the United States Department of Labor, issued a new joint employer rule. And they proposed this new rule on joint employer status under the Fair Labor Standards Act, the Family and Medical Leave Act, and it scales back significantly broader Biden era approaches, emphasizing actual control of the relationship, the joint employer situation, with a four-factor test for vertical joint employment and focusing on sufficiently associated activities or entities for horizontal employment.
Oh
So
my gosh,
many,
I'm not even sure I understood what you vertical, horizontal, sophisticated. All right, break that one down for me, just in layman's terms.
yeah. So I think that the most important thing that people can do right now is if they want to comment on this, the Department of Labor is taking comments on this new proposed rule through June 22nd, 2026. And this new rule really offers a lot of relief and clarity for staffing firms, tech and other companies that use vendors and contractors, and it aligns with the broader Trump era effort to reduce liability exposure for employers. It really does focus on actual control that the employer
Mm,
that the primary employer actually controls the terms and conditions of employment of the secondary employer in order to have a joint employer relationship. If they don't
okay.
exercise actual control over the terms and conditions of employment, the chances are this will not be a joint employer relationship, which is a very good thing for business.
Good thing for business.
Yep.
Awesome. What else you got there, lawyer on the clock?
All right. And while I'm still on the Department of Labor, just about a week ago, the Department of Labor issued a technical amendment on the Fair Labor Standards Act exempt salary threshold. The DOL issued this technical amendment, which restored the 2019 salary levels for FLSA
Mhm.
white collar exemptions, returning it to $684 per week, or $107,432 per year for highly compensated employees. And that formally removes the vacated 2024 increases. So just remember, we were kind of getting geared up for some significant increases to the salary threshold. Those things were scaled back by court decisions, and now the Trump administration has formally returned to the 2019 salary levels.
All right. Well, we've been through a lot of work on both of those topics over the
Yep.
last 7 years, you know.
Yep.
Again, a great example of like, let's just settle in so we can all move forward together and
Yep.
keep looking forward instead of left and right, or how did you say it? Vertical and horizontal.
Sure. That
Maybe,
I
maybe
always
spinning our heads.
I always refer to that as that pendulum swinging wildly from right to left, depending on who's in the office, from left to right, right to left.
Absolutely. All right, man. This is a good topic. I like this one. Just
Yeah.
coming off of our leadership conference and having Jay Samit on the stage and talking about the future and AI and the things that are in front of us. And one of the things that our employers are dealing with, and it's real and it's here. It's not the future. It's now. And that is like these smart glasses, these digital smart glasses that are out there. And the smart devices, while we're going to use the example today and kind of focus on glasses because that's something we can visualize. See how I did that? Um, there are all
Phil,
kinds of
Phil,
smart devices.
Phil, don't be a glass hole. Okay.
There you go. All right.
All right.
Well, I can see how this program is going to go. We've started out in the wrong direction, but let's keep going and maybe we'll get a compliment on our edutainment here. Um, But there are more things than glasses to be concerned with. I think it's the concept that we're going to talk around glasses and recognize it can be buttons, pins, recording devices, phones, all kinds of things that we don't recognize people might be using to access, record, capture information,
Mhm.
maybe to help them be more productive, more safe, more efficient. But we're just not aware of it. And that's really the challenge that employers are facing today. So when we think about that, and there's CEOs and HR business leaders, what should they be thinking about as they start to see these types of technologies in their operations?
It's really kind of balancing the promise and the peril of these technologies, including the smart glasses, the smart glasses in particular, and other devices such as headsets. They provide hands-free instructions and real-time assistance, but they also raise serious privacy and compliance issues because they can record audio, video, and even capture biometric data without obvious cues.
Yeah. That's interesting on the biometric data. I was just meeting with an AI consulting firm this morning, and one of the things that they provide is biometric reading and scanning of technology because there is a problem, and I'm kind of going off path, but I think it emphasizes the importance and the advancements of technologies. So one of the products that they sell is um, a concept that your camera will be scanning your employee while they're working and it
Right.
catches biometric changes. So, for an example, if you think I'm your employee doing the work and I step to the side because I work from home and then somebody else steps in is doing the work, that scanning would catch that and cut off all
Mhm.
technology and that kind of thing happens in some places, right?
Yeah.
Or somebody else logs in from another place and it's not the right biometric measurement, it never opens up for them.
Mhm.
And the same thing can happen with glasses and these other things. Now, I'm sure there are legal risks around this that we should be thinking about when glasses are capturing audio and video and even faces. What are the like most pressing legal risk for employers in that case?
I think you mentioned at least some of them, Phil. Key risks would include violating privacy laws by recording without consent, capturing biometric data, the one you mentioned that may trigger state statutes like Illinois' BIPA
Yeah.
statute, Biometric Information Privacy Act statute, and really creating evidence that could be discoverable in litigation, evidence that might not otherwise exist. Employers have to be mindful of employee rights under the National Labor Relations Act and ensure that the policies don't run afoul of labor law when they try to rein in the use of some of these technologies or permit
Yeah.
or otherwise permit use of these technologies.
How about like, so maybe it's Illinois or other states. How do state laws around consent to record interact with like these wearables? So sometimes
Mhm,
these glasses are prescription glasses with this technology bought in or built in.
mhm.
Um, could an employee inadvertently commit a crime by wearing them, recording, but the employer isn't aware? Like, is that burden on the employer? Or is that on the employee?
It really is on both. States like Illinois, and I think there's about a
Yeah.
dozen states that require all parties to a conversation to consent before audio can be recorded. And so if the individual is the one wearing the glasses and they know that it's recording, that those glasses are recording, they're really the ones who have to obtain the consent. If the employer is either requiring or permitting an employee to use glasses that record, then again, I think the employer is
Mm.
taking a risk if they don't obtain consent and at least make a disclosure that these devices are being used in the workplace and obtain consent from the employees. I had a client reach out to me very recently where they are using it's an amazing device, but they require their employees to carry radios with them at all times in the facility. And what these radios do is they
AM,
real
FM
time,
radios? What kind of radios? CB radios? What do you
yeah,
mean?
two-way communication radios.
Okay,
And
gotcha.
what these devices do is they translate language in real time. So if you have
Ah,
a multilingual workforce and you're speaking into your end of the radio, somebody else on the other end, depending on how they have their radio set, will hear your comments or questions or remarks in Spanish. And then when they
right.
speak back to you in Spanish, the radio will automatically translate that in real time into English so that the workforce can communicate seamlessly. And
That's very popular in like customer service
mhm,
businesses today. I'm aware of that.
yep.
Absolutely.
So if an employee uses smart glasses to capture a conversation without everyone's permission, both the employee and the employer could face civil liability or even, get this one, even criminal charges. And
Hmm.
so companies really need to educate employees on applicable consent laws and restrict recording in sensitive areas because you also have a whole host of trade secret issues that could be implicated by these devices.
Yeah. So having a no recording device allowed policy, which is common in like a
Mhm,
handbook and things like that. When we wrote those types of um, those policies and put them into handbooks, I don't know that we always wrote those with this type of technology in mind. And
yeah.
so what comes to mind, my next question is, because I can see how this plays out. I mean, HR leaders have a darn tough job when they're going to say, look, you can't wear those glasses. And they're going to say, hey,
Mhm,
I just spent, you know, $800 on these glasses and frames, and they are my reading glasses. This is what I need to see. How does this maybe run afoul with the National Labor Relations Act or anything like that as to issues that might create where we're saying you can't record, but hey, I have to wear them or use them, and we don't know.
Yeah, the National Labor Relations Board, and frankly, some of the courts have held that if employers can have no recording policies, but there have to be exceptions to those no recording policies for things like documenting illegal activity. So if an employee wants to record something so that they have documentation, video evidence, or audio evidence of harassment or discrimination or an illegal practice that might lead to a whistleblowing complaint, violations of environmental laws,
Yeah.
something again that could be whistleblowing. The National Labor Relations Act says that employees have those Section 7 rights to engage in protected concerted activity. And if an employee wants to record their employer interfering with the employee's Section 7 rights, the National Labor Relations Board would say that the employer has to make exceptions for that. So the court-related exceptions for whistleblowing, harassment, discrimination, National Labor Relations Board created exceptions for documenting behavior by the employer that might interfere with the Section 7 rights. So you can have
It's
those
tough.
broad no recording policies, but just remember, ultimately, at the end of the day, while employers can ban recording only where there is a legitimate business justification, such as protecting confidential or proprietary information, blanket prohibitions without nuance definitely invite legal challenges.
Yeah, and I think that's going to be the tough part. If I think even like a fork truck driver, and it's like, well, there's maybe everything's packed, wrapped, you can't see it. The confidentiality, the trade secret doesn't really exist in that space, and the fork truck driver has his or her fancy glasses and they want to record and do like that. That's going to be difficult. And I'm going to guess the ADA. My next question leads into the ADA is probably got a position on this as well, and this is what makes your job, my job, and the HR leader's job so complicated in mitigating risk.
Yeah, and what the EEOC and again the courts are going to look at is these have to be individualized analyses. Smart glasses can serve as assistive devices for people who have vision impairments. So employers should treat requests to wear smart glasses like any other accommodation request. They should engage in that interactive process, evaluate whether the glasses are medically necessary and whether alternatives exist. And, stay away from those blanket bans on smart glasses and assistive technologies because that can backfire when a physician has prescribed them.
Yeah, and I think that's going to be the difficult part, right? Because there is translation that occurs through the smart glasses as well. You speak in English and it translates into my glass lens in Spanish or any other preferred language, just like it does translate in the radio device, the verbal response. So that's going to be really complicated here. And I think businesses are going to have to probably, adopt practices that they're not as comfortable with that might cause them problems in other areas. And once one person has it, and I know what will happen is they're going to say, well, I'm not recording. And someone's go, I don't trust that guy.
Right.
I know he's recording. She told me she's recording or she's doing this or whatever happens. So I'm just curious, like, if you were wearing those, could I say, I want a copy of that recording? Can I ask that and require someone to give that to me if you were
Yeah,
recording that?
you can ask. I don't think anybody's under an obligation to provide it absent some sort of court order.
Yeah.
Again, it sort of turns on that consent piece, though, that the person really shouldn't be recording in an all-party consent state like Illinois unless they obtain the consent of other
Consent.
people.
Right.
Yeah. In a state like Missouri, which is one-party consent, if they're a party to the conversation, they can record it, and they don't have to obtain consent from others.
Yeah, and I've heard in our roundtable discussions and different things that we have employees that record everything all day long.
Hmm.
I mean, it's really a difficult spot. All right, so you mentioned BIPA earlier in
Yep.
Illinois. How do smart glasses fall under these laws, and how should employers respond in this scenario? Anything for our Illinois listeners there?
Yeah, and I'll focus. We'll talk about the smart glasses and those radios I mentioned before too. So, like, if with respect to the glasses, if those glasses capture facial recognition or eye tracking data, that may constitute biometric information. So, BIPA
Mm,
requires written notice, informed consent, and data protection practices. Uh, the radios that I mentioned, voices that are transmitted, and if transcripts, recordings are made and transcripts, a voice is biometric data. And so again, you have to comply with those written notice provisions, the informed consent, and the
mm,
data protection practices. Even when liability may not attach directly to a low-level employee's device, the employer should update privacy policies and provide clear disclosures to employees and oftentimes customers or clients.
mm. It's getting complicated, buddy.
Yep.
Long gone is the days where you had your boombox radio and you stood by the AM FM transmitter of that with your cassette tape and you waited for your favorite song and you had your play record button and you hit at the same
Yep.
time so you could record the song that the DJ was playing. A lot easier back then for sure.
Hey, yeah, except then, Phil, we just would pray that the DJ wouldn't talk over the beginning of the song or the end
I
of the song.
Yeah, it's like shut up. Yeah.
Exactly.
I was like, Radio Rich, what are you doing? Be quiet. Yeah.
You just ruined my golden moment.
That's right. And I have to wait for that song to play
Yep.
again in the next hour. Yeah, anyway, let's get back on track. How let's talk just a little bit about what these glasses might mean from a litigation standpoint,
Mhm.
company records, anything like that that is worth talking about, or want to move on to a different topic?
No, I think it's really important. Video and audio that's captured during work may be deemed to be business records and therefore subject to discovery and lawsuits. So employers really need to consider retention and destruction policies for this type of data and ensure that they're not inadvertently creating evidence that could be used against them down the road. This would
Hmm.
include training employees on when and how to use smart glasses at work. And an easy example could be if you have an employee using smart glasses for something like augmented reality on an assembly line. And it augments the reality going on in front of them and sort of has images of exactly how the pieces fit together and what they need to do to properly assemble it. And somebody gets injured in that process while it's recording. Well, now
Yeah.
all of a sudden the employer has evidence, uh, documentation, video, audio of what happened to cause the accident. And that would,
Yeah.
if that's a business record, that probably needs to be, it's going to need to be preserved. And so
For sure.
employers need to
Yeah.
be thinking about these things. If
Yeah.
somebody's just wearing smart glasses in the workplace and they capture a forklift driver running over the feet of another employee, boom, there's evidence that you need to think of all of that.
Yeah. No, that's I mean you're really helping bring a lot of this in perspective. It's far more complicated than
Mhm.
it appears on the surface. When we think about some of the benefits that might come along with the smart glasses, what do you see as some of the unique benefits or challenges to that?
Um, well, I think
Any
that
particular industries, jobs,
yeah,
smart glasses? Yeah.
yeah, definitely retail, warehousing, like I said before, manufacturing in particular,
Yeah.
field service work like electrical, plumbing repairs, they may benefit from hands-free instruction, real-time translation, and augmented reality. Healthcare is another one, certainly that will benefit from hands-free instruction and augmented reality. Um, Healthcare and finance carry heightened privacy obligations. It's one thing if you have a plumber using augmented reality to fix a leaky pipe, Another thing, if you have a healthcare provider using augmented reality to operate on somebody's heart or brain.
Hmm.
And so there's definitely heightened privacy obligations in those industries. So employers in regulated industries really are going to have to be extra careful because recorded data could include sensitive personal or financial or health information that is to be protected under the law.
Yeah, and what's coming down the road today, we're still talking about maybe wireless external devices.
Mhm.
I bet, Bert, hopefully before you and I are done, we're going to be talking about implants and things like that. That is going to make it even more difficult. So
They're
as
they're
I
they're already working on it. They're working on a contact lens that will obsolete the smart glasses. It'll be a
right.
lens that literally sits in your eye and provides all that information that the smart glasses are providing today.
As well as seeing spectrum of light that our human eye doesn't see and all kinds of different things.
Mhm.
So that kind of leads me down to, okay, great. Great, Bert. What the heck do we do about that? What should we be thinking about when we're writing policies or establishing our workplace rules? What first comes to mind for us to consider other than we know it's like turn to Ogletree, turn to AIM. We'll help you with these types of policies. You can see how complicated they are. They need to be involved in designing them with your workplace and discussions around philosophies and other things in mind. It's not
Mhm.
as simple as even time and attendance. It's very complicated. So get us started in that space a little bit.
Yeah, first I would really hone in on what the laws are in your particular state, as far as are you in a one party consent state or an all party consent state for recordings. Second
Mhm.
of all, I would follow regardless, I would still provide notice to employees that these devices are in use when they're in use
Yeah.
and would follow consent laws. I would follow, there's Illinois BIPA law requires an opt out if employees don't want to have their biometric data recorded. There needs to be accommodation made or at least a discussion. So policies really need to address the specific capabilities of smart glasses and other assistive technologies. The policies need to prohibit recording in sensitive areas, uh,
Yeah.
prohibit recording of trade secret, confidential information. Policies should also outline data handling practices, update your confidentiality agreements, and you may need to involve IT, privacy counsel, and frontline managers to ensure that the policies are legally compliant, but also practical in the workplace.
Yeah, that's good advice. Very good advice. I know as much as I hate to admit this, I do know organizations kind of take a wait and see and, kind of let some of the water run under the bridge before they jump into a policy. There's definitely risk involved in something like that. Let's talk about that.
Yeah. I mean, waiting always invites lawsuits, union grievances, potential criminal prosecution for violations of Illinois' uh, uh, all-party consent law to recordings. Can also impact your reputation in an industry. Early adopters who fail to set boundaries can face some steep statutory damages under biometric laws, potential claims of discrimination if they mishandle accommodation requests. So I really do recommend a proactive approach that would allow employers to mitigate exposure before the
Mhm.
problems arise.
Yeah, yeah. And if we're looking ahead, it's more than just, hey, we're going to hang this sign, recording devices in use, right?
Yep,
That's not what we're talking about. What
correct.
are some of the other proactive steps organizations can take to prepare for wearables in the workplace?
Yeah, so now is not too early to start. Employers should start developing those clear policies that address smart glasses, other wearables, training the employees on the consent laws and privacy expectations, update the confidentiality policies, uh, create or update your bring your own device, your BYOD agreements,
Yeah.
conduct an audit on how these devices intersect with your legal obligations, and really build a consistent process for accommodation requests. If you stay ahead of the curve, Phil, that will obviously save headaches down the road.
Yeah. And, throughout the conversation, Bert, all I've been thinking about is like, it comes down so importantly to your workplace culture, right?
Yeah.
Again, in this scenario, most of the conversation has been around um, people who might try to do things to push the limits or to execute their rights. And often they're doing things like that because culture isn't what it needs to be.
Mhm.
Not everybody's all for one and one for all approach in that. So it is a critically important with culture. And I agree with you. It is about getting out in front of it.
Yeah.
And I guess I'll kind of leave the audience with, the concept that, AI is unlocking incredible gains in speeds, insight, productivity. We've seen this, but not every consequence is obvious at first glance. You see how I did that one? Yeah.
Yes.
Insights,
Nice.
first glance. Bert, I'm
Yep.
throwing these out there. You're not following me now. All right.
Yes,
Um,
exactly.
Leaders really do. We have to empower our teams. We got to be able to move faster while staying vigilant. All right, never mind. Because a single misstep involving privacy, compliance, accuracy, or confidentiality can become tomorrow's business risk. And, avoiding that risk and staying in front of it, even if we don't get it exactly right, is better than ignoring the risk and letting it take us in a place we don't want to go.
Phil,
Anything
I
else you to
think it
close
we've
with, Bert?
yeah, I think we've come full circle. If you put your head in the sand here, it's going to be risky business, and you're really taking your chances from a liability standpoint.
Yeah, I like it. I can't beat that one. All I can say is join us here. We're going to be back in a couple weeks when we're going to get together and we're going to talk about the Department of Labor's new proposed rule of joint employer liability. And until then, go out and be good to someone. Take care.